CLE. My name's Dominica. I am the coordinator here at the CMBA for CLE. If you opted to receive CLE for viewing this program, be sure that you are viewing this program on your computer or phone as opposed to calling in and listening to audio only. Additionally, I will follow up with everyone with a brief survey. Make sure you fill that out completely and you will get your CLE credit. And I will repeat that at the end of the program as well. So I will kick it over to Jay. Thank you for introducing our panel and moderating. Happy to have you.
Hello, ladies and gentlemen. Welcome to the CMBA, to the Hot Talk, to bail reform, which is truly a long time coming. There will be three speakers today: Anthony Boddy, Jonathan Witmer-Rich, and Claire Chevrier, and I will introduce them as they come along. I believe in that order. But I just want to talk about something regarding bail before we start. Our conversation today will be about bail at the state level, bail at the municipal level. But we've talked about as a baseline for all of this to discuss bail at the federal level, because that is a more detailed, more sophisticated, not necessarily better, system than what we are using now. And by that, I mean this. In federal court, if you're charged with a federal crime, there are only two ways, practically, that the court can go. You can be detained in federal court. Detained means no bail at all, and it does not have to be a capital case. The basis for it is danger of flight and danger to the community. There is a very real presumption in federal court that you will not be incarcerated. And I believe, at least here, and I believe all over, the federal magistrates and judges are trained to follow that presumption. If you are not detained, and detention is a relatively small percentage of the people going through federal felony court or misdemeanor court, if you are not detained, then there is no cash bond. As a practical matter, it very seldom ever happens. Your finances will not be an impediment to your release, which is, and you can tell in those, when we're talking about today, we'll talk about municipal court cases, minor cases where bail changes people's life. In federal cases, you may note that we had our $60 million fraud here in Ohio, quite an extraordinary thing by all accounts. And on signatures, people were released. So anyway, that's the baseline for this. I think we should begin the discussion. Anthony Boddy is our first speaker. Anthony is well known and deservedly respected as a community activist in Cleveland, and specifically to some extent in the Glenville area. He is particularly known for his passion, and as I say, for respected. And then there's one thing that he said about himself that I have no clue what he meant, so I'll ask him for all of us. He said he was a bail disruptor. And that may be a turnabout I've never heard, but Anthony, what are you talking about?
So before we even talk about bail disruption, I'm glad you mentioned the federal system. So I originally wasn't going to participate in the call because a friend of mine who was currently incarcerated down in the federal holding facility in Youngstown. And then ultimately, as you said, he was charged with a crime and he was in pretrial detention in the federal institution, but ultimately he ended up dying to COVID this past Friday, and he hadn't even made it to court of anything. So it shows how flawed the system is, whereas it was a drug charge that he may have been found innocent of, but he was sentenced to a death sentence because he was sitting in that federal holding facility with no bail and he wasn't released. So it's a lot of work that definitely needs to be done. But as a bail disruptor, you know, I work for an organization called the Bail Project. We're a national nonprofit, so we're a national revolving bail fund. We currently have 29 sites across the country, but here in Cleveland, we've been here for over a year and a month to be exact. So my role is exactly what it says, to disrupt the system, a system in which there's a lot of unjust practices. The system's supposed to be you're innocent until proven guilty, but as we know, for certain social folks in certain social economic groups, you're guilty until proven innocent. So poor folks are faced with harder means being able to obtain their freedom. So we have a financial threshold, and when we assist people with bail who can't afford bail, we give them up to $10,000, 10%, and up to $5,000 cash surety. we post their bonds to sort of disrupt the system in a way where the way the current system works, it states that a person's freedom is solely attached and based upon them setting that surety or that cash amount and making sure they return to jail. So to date, we've posted bail for upwards to 250 plus people, and none of them had any financial attachment to the system, but yet and still we have a 96% return rate. So it shows that the system and the way that they are suggesting that people's freedom should be attached to a dollar amount, it shows that it's flawed. So as a bail disruptor, not only do we post bails, but we also provide advocacy work. And that advocacy work consists of housing, if you have drug abuse problems, rehab, jobs, transportation back and forth to courts, literacy problems, because we all know that education is also attached to the possibility of you being within the criminal justice system. So on a daily day, our role is going down into the Justice Center, interviewing clients, meeting with some of the judges, working with some of the public defenders, and helping people gain their freedom. And that's who I am as a bail disruptor. That's it. That's all. That's really, you asked that question just to answer your question. So do you want me to go for it?
Keep going.
So being here in the system, being here in the city of Cleveland, we show how flawed the system is. It was just recently an article printed, I believe yesterday, that showed that Judge Brendan Sheehan agreed to extend jury trials. Jury trials won't begin until September, however long. But we all know that within the Sixth Amendment in the Constitution, it states that we're all supposed to be able to have and granted a speedy trial. So one of the things that we try to deal with and combat as bail disruptors is how a lot of folks' constitutional rights and civil liberties are being violated down in the Justice Center. So you have a lot of folks who, as I said, can't afford bail, and a lot of folks who can afford bail tend to plead guilty to crimes that they may not even be guilty of, because our system uses those plea deals as bargaining chips to allow people to gain their freedom. But also some prosecutors use those chips to keep their conviction rates high and so forth. And we're just trying to just expose and use the numbers and the data that we collect on a daily basis to show that there needs to be a change and a true change and effective change. People really need to try to stop band-aiding things and address issues at their core. That's all I have, Jay, right now. If you have a question.
Fair enough. Fair enough. You folks are able to ask questions either through chat or through the question and answer. We do have a question and answer, so let me answer that live now. I was actually typing, I apologize. The answer, but let me answer that live now. The question was, the federal bail reform that resulted in what Attorney Milano was describing went into place in the 1960s, I believe, and resulted in a dramatic increase in pretrial detention. How is that an improvement? And please understand, and that was Stephen Johnson Grove, Mr. Grove or Mr. Johnson Grove. I am not an advocate of the federal bail system. I am certainly not an advocate of federal detention. But I opened with that to let you know that in substantial cases, serious felonies, people are let out on a signature, while in minor misdemeanors, minor not in the technical term, people are jailed. And I think we'll hear before we're done today how much spending a day or two in jail will affect a person's life. So I am not an advocate. And just please excuse me, old men tell old stories. I recently became involved for the first time in a long time in the Federal Criminal Justice Act system, and have been given a number of drug cases, and I am profoundly distressed, though I always knew this is true. I've done criminal defense all my life. And the people going through the federal system at this point, at least in my minimal experience in the last year and a half doing this, are all Black people selling small amounts of dope who are facing mandatory time. And that is who ends up getting detained. That's where the chances are. So I am not a fan of the system. I merely laid it out to give us a counterpoint. So take it for what it's worth. So Jonathan Witmer-Rich is our next speaker, and I have been instructed, and I will gladly do this because it's important, to tell you exactly who Jonathan is. Jonathan Witmer-Rich is an associate dean and Joseph C. Hostetler, BakerHostetler, professor of law at Cleveland Marshall College, Cleveland State University. I am sure that he was ordered to do that because BakerHostetler gave a lot of money to the school and they want their name out there. And I'm sorry, that I didn't mean to insult them. And the reason I think I can get away with it is I know how good Jonathan is. He and I worked on the state, Judge Russo, the presiding judge in Common Pleas Court's bail task force. That started with 100 lawyers or more to giving input. The 100 lawyers fell off very quickly. That was a very giant. And then it got down to 4 people in the end working on it, 3 of whom were just hanging around. And Jonathan, who wrote the report for Cuyahoga County, as the product of those 100 lawyers, every one of which took credit for it. But I watch him masterfully distill the system. So I'm not surprised that he is the counsel for the Ohio Rules Commission. I'm not surprised that he holds a very prestigious chair at Cleveland Marshall. And now I'll shut up and let him talk.
Okay, thank you, Jay. So I'm going to kind of pick up where Anthony left off, and I'm going to talk specifically about some bail reform efforts in the state of Ohio and where those are at, and frankly, how some of those have recently failed or stalled out. And then we're going to turn to Claire Chevrier from the ACLU, and she will talk a little bit about her vision for what effective bail reform could look like. So, I mean, the fundamental question I think that Anthony's talk raised is this idea of, I mean, what is the purpose of money bail? And traditionally, pretrial release, we think of 2 important concerns that the criminal justice system has with regard to pretrial release, and that one is to make sure people show up for court, they return, and the other is to protect the community. And what I'd like to focus this on for a moment is, when we're thinking about money bail, what role does money bail play with respect to those 2 purposes? If we think about having people show up to court, then I think we can all understand the role that money bail can play. Now, of course, if you're setting money bail for somebody who doesn't have any money, you're not incentivizing them to show up to court. They're just going to be detained. But, you know, if we get some well-off defendants, most of whom are not well-off, but if Jay Milano shows up as a pretrial defendant, you know, he could post some money bail.
Whoa, never say that.
So you know, Jay, on a $10,000 bond, he can put some money down, and that makes sure that he doesn't skip town and go to Mexico on us. But most defendants are not in that position, right? And instead, the second question is, what role does money bail play with respect to that second issue, protecting the community? And I would suggest that the answer is, and this is consistent with what bail reformers have been saying for decades, it plays no role whatsoever. Money bail should play no role whatsoever with respect to protecting the community. And why is that the case? Well, money bail is it's one of 2 things. It's either a detention order or it's a mechanism of release, right? And with respect to protecting the community, if you set a $10,000 bail and the defendant posts it, then they're released, they're in the community, and you've done nothing to protect the community. There may be other things you can do, conditions, supervision, that kind of thing to protect the community, but the money bail is doing nothing for you. The other outcome is the person can't afford the money bail and they end up being detained. Well, I mean, that does protect the community from further crimes, but then the question is whether that's a just outcome. In Ohio, as in the federal system, like Jay was saying, there is a mechanism for actually just ordering somebody to be detained. No bail, you have to be detained. And that's justified under Ohio law, under the statute 2937.222, when you are really dangerous. And the court holds a hearing where you're represented by counsel, it's adversarial, the court has to make certain findings, the burden is on the government to demonstrate that you need to be detained. So judges in Ohio never do that. They never hold those hearings and order someone to be detained. And what they do instead is they set money bail as a way to detain people. And that is a fundamental problem. It's been called one of the most significant pathologies of our bail system, is this use of money to detain people. Rather than hold a hearing where you're represented by counsel and the judge has to make findings to say this is why this person needs to be detained because they're so dangerous, we just set a higher bail amount, and then some of those people, many of them, end up being detained, and a few of them, the ones with more money to their names, end up getting out, even though there's no difference between how dangerous they are to the community. So at the statewide level, this culminated in some proposed reforms. The Ohio Rules Commission, which I'm now a member of, was looking at amendments to Rule 46, which governs bail in Ohio. And we proposed a rule actually in the fall of 2018, and we proposed it again in the fall of 2019. The Rules Commission operates on a yearly cycle, so we have to propose things in the fall of one year, and they don't go into effect until the summer of the next year. It's a lengthy notice and comment period. So for about a year and a half, we had proposed a rule, and the rule had a number of components, this proposed amendment to Rule 46, but one key component was this. Any financial conditions of release, so money bail, quote, shall be related solely to the defendant's risk of non-appearance. In other words, you can use money bail to incentivize people to show up to court if they have some money and it can serve that purpose, but you cannot use it to detain them because you think they're dangerous. If you want to do that, you have to use the statutory scheme that's set up where you have to hold a hearing, it has to be adversarial, you make findings and so forth. You can't use money bail to address the defendant's dangerousness. So that went through a lengthy notice and comment period, really about a year and a half. And unfortunately, in March, that proposed rule was changed by the Rules Commission, and then the Ohio Supreme Court published this proposed rule, and that is the change, I believe, that has gone into effect. And that rule was changed in a very significant way. And now it reads as follows. Financial conditions shall be related to the defendant's risk of non-appearance, the seriousness of the offense, and the defendant's previous criminal record. That specifically is basically telling us, you judges in Ohio, if you want to set a $20,000 bail on somebody because you think they're dangerous, go ahead. So, you know, that's where we're at in Ohio right now. We had proposed a rule to say we need to stop using money to detain people because we think they're dangerous. There's a procedure set up for that under the revised code. And unfortunately, in my view, the Rules Commission and the Ohio Supreme Court in the most recent go-round, they moved away from that. And they said, nope, we're going to stick with the system where if you want to set a high bail on somebody because you think they're dangerous, that's an okay way to do it. So I think until we change that basic issue, we're gonna still be running into problems in the state of Ohio. You know, Anthony's organization, the Bail Project, is demonstrating, you know, why that makes no sense. They're coming in and posting bail for people they don't know, they don't have any connection to. They're a nonprofit, right? Posting bail for some guy who a judge put a high bail on because they thought this person needs a high bail. They post that bail, the person gets out, contrary to the judge's intent. And as he's reported, they have a 96% return rate on those over 200 people they posted bail on. So I think they're illustrating through their conduct that this is unnecessary and unjust and unwise. So that's where we're at in Ohio right now, and I'll turn the floor over to Claire.
Claire, before you go, can I ask a question about what Jonathan said? And maybe this will be what you're going to talk about anyway. Is that okay?
Oh, of course, go for it.
So here's the question for all of us. What you offer will be an opinion based on evidence and experience, but it's your opinion and maybe the opinion of your organization. But why? Why are we so resistant to the type of bail we're talking about? I wanted to say enlightened bail and I wanted to say fair bail, but the type of stuff we're talking about where bail is not a factor of danger to the community, or high bail is a attractive option for a judge.
So, Anthony, you can go ahead.
Well, I don't believe high bails are attractive to judges. Like it goes to the whole election or democracy. You know, a lot of these judges are, especially, I'm speaking specifically down in the county, a lot of these judges are elected officials. So we think about the voter turnout, we think about the folks who vote, you know, some folks tend to favor the community at large or the optics of what will be presented in the news from them releasing someone who's accused of whether it be selling drugs, domestic violence, or murder, or any other high media attention crime. So they don't want that public backlash. They don't want to lose that opportunity of potentially being reelected. You know, while we do have tons of judges that's currently sits on the bench who's on board with posting bails and understanding like the system and putting systems in place to make the odds and the possibility of people not entering the system again, but also them returning back to court, whether it be giving a personal bond, giving them house arrest, but also putting systems in place where they require these folks to go seek a job, to seek housing, make sure that they're getting their meds and so forth. But I think it's just solely based off judges not wanting to receive that backlash and not being able to stand behind why they made that decision. You know, with bail, one of the things that I realized being down in the county where there's no cohesive or no structured way of setting these bails. You know, each judge has their own bias. You know, you can see a $20,000 bond for a domestic violence for one individual when you'll have another judge will set a $50,000 bond. So with this discretion, each of these judges is just different strokes for different folks.
Who else?
I had a quick answer that's somewhat of a preview to what I'm going to be discussing. Right now, one of the easiest things for a judge to do in Ohio is set a bond and move to the next client. In some jurisdictions in Ohio, the first appearance is by video camera, but counsel is not provided, and a judge makes a decision very quickly based on the limited information they have, sets a bond, and goes next. And that's because the system that we've created and that we've allowed to continue makes it that's a really easy thing for a judge to do. And I think there's also this misconception because one of the most frequent questions that I get at ACLU of Ohio is, so the ACLU wants to release murderers, you know, the really extreme example. And the answer is no. And similar to what Jonathan was just saying, there are laws. 2937.222 is the preventative detention law, but you never follow it in Ohio. In fact, Ariel Castro, who was ultimately convicted of like over 900 crimes, including some of the most serious crimes that exist, he wasn't preventatively detained. A judge set an $8 million bond for him. And that's dangerous, you know, in the times of GoFundMe pages and, you know, international wire transfers, because that man could have gotten out. But also the point isn't that we're trying to release everyone. The point is that even for those charged with the most significant crimes are still entitled to due process, and they should still be able to go through the very significant procedural safeguards laid out in 2937.222, which require a number of different things before someone is preventatively detained. But for the vast majority of people, cash bail is not going to act as an incentive to return to court. Either, you know, the amount next to your name that's set in bail is something you can pay, so it's not really going to act as an incentive, or it's an insurmountable amount that's going to cause you to remain detained, and so that's also not serving the purpose. So clearly, even though right now one of the easiest things a judge can do is set bond, it doesn't actually make sense for the purposes of why bond is allowed. And so some of what I'm about to discuss is what we do need to change, what we need to create in our law to make it so that setting cash bail very quickly and moving on to the next accused individual is not the easiest thing to do. We need to have what is, you know, what makes the most sense be even with what is actually occurring on the ground.
Is there a municipal court pressure to set 10% bonds or to set not necessarily bailman bonds? And please excuse me, but some of you may not be too deep into this. You know, there is a bond post by a bondsman, which is 10%, and the money stays with the bondsman. And they post an actual bond, an insurance policy. There's also 10% where the money is returned to the client. Have you seen any pressure in the municipal courts based upon the fact that if money is posted at 10%, that money is ultimately used for fines and costs?
Yes, I think so. So as you pointed out, you know, the 10% system in theory seems superior. Jay gets arrested, right? And it puts a $10,000 bond on it.
You don't understand. I'm scared of that.
He can pay $10,000 to the municipal court clerk, rather than paying that to a bail bondsman. That's his 10% bond. When he's done at the end of his case, if he's showed up, he gets 90% of that back. So he gets $900 back out of that $1,000 that he posted, except actually he's not going to get that back because the way his case is resolved is very likely going to result in some fines and fees, or maybe he has previous fines and fees from a previous case that are outstanding. And it turns out that, let's say he's going to have $840 in fines and fees. They're going to use that $900 toward those fines and fees and hand him $60 back instead of the $900 back. So that's a built-in incentive for courts to set a bond so that the person is in essence prepaying their fines and fees before they've been convicted. And so it's a really bad incentive that exists for municipal courts to essentially use people's freedom as a way to make them prepay what they think are going to be their fines and fees at the end.
The only cheat code to that incentive that they set in place, if these courts offer that option, in which how we operate, if the court offers the option for the depositor to receive that money back and it's not within that potential client's name, and then whatever the disposition of the case is, 90% of those funds are returned back to the person who deposited those bills, not to the individual case fines or fees. But with these smaller mayor courts and smaller municipalities, those courts don't even allow for other depositors to post bill for them on a 10% bond. They want cash in full.
Let me ask you guys this, and Claire.
Yeah, I'm going to take back my turn in a minute. Go ahead.
You take your turn now if you'd like.
Yeah, give Claire her chance.
Sure. So I'm going to talk about what reform should look like. What can we create? What procedural safeguards can and should be added so that we stop seeing what has been described? But I'm going to start with talking about what bail reform should not include. And in our opinion, that is risk assessments. So risk assessments were created because there's this recognition that humans are flawed and judges are humans. And so presumably decisions are often made based on implicit, if not explicit, biases. So it was exciting, this idea that instead of having a potentially biased individual make decisions about pretrial detention, that instead the detention determination would be made by, an objective computer algorithm that can't have the same biases. And that was really exciting. And a lot of different jurisdictions rapidly, started working with risk assessments, purchased risk assessments, developed risk assessments. But unfortunately, what we've seen now is that there's no way for a computer algorithm to be objective when the only information on which it's making its decisions comes from the biased criminal legal system. So I'm going to quickly go over, what is a risk assessment and what kind of factors does it look at? So one of the factors that a lot of risk assessments look at is arrests. So not convictions, but just arrests. But we know that people of color are significantly more likely to be arrested for things that they have not done, and are more likely to be over-policed for things that white communities get away with all the time. So arrests is not really an indicator of whether or not somebody is a public safety risk or a flight risk. It's more a determination of police biased decision-making. So some of the better risk assessment tools don't even look at arrests because they recognize how problematic that is. Almost all risk assessment tools look at convictions. But we know, because we learned, in criminal law, that 90% of convictions in this country are made via plea deal, not by going to a jury trial. And we know that there are significant coercive factors that exist to push people into taking a plea deal, even for things that they have not done. And that those coercive factors are way more significant in a jurisdiction like Ohio, where judges over-rely on cash bail. We know that within 3 days of somebody being held pre-trial, often in Ohio because they can't afford their bond, they're likely to lose their job, they could be put at risk of losing their house, and they can even be put at risk of losing custody of their children. For many people, the only reasonable option is to take a plea deal, especially for some misdemeanors. Taking a plea deal might mean you get to go home today, whereas fighting to demonstrate your innocence could mean weeks more in jail, maybe because you're held on a $300 bond that for someone else might be nothing, but for you means you're kept away from your children and there's no one to watch them. So convictions is also still an indicator of biased police decision-making, and then whether or not you were coerced enough to take a plea deal. It's also not necessarily, even though we think of it as such, it's not necessarily an indicator of whether somebody is a safety risk or a flight risk. So then outside of convictions, what else is there to look at for determining whether someone's a risk? And so one of the things that some risk assessments look at is, well, have you failed to appear in the past? And that seems like a better one, more tied to, are you going to fail to appear in the future? But I usually tell this very quick, honest to goodness true story that when I was practicing in DC, we were in the middle of a trial for my client in the afternoon, and this woman in a thigh to ankle cast and crutches came crutching in and interrupted the trial, which you can imagine resulted in a little bit of brief chaos. And, the judge saying order, and it turned out that she had a hearing in that courtroom at 9 a.m., had slipped on ice in front of the courtroom, had been taken in an ambulance from the courthouse to the hospital. Turned out she had broken her leg. She was put in a cast, and she came straight from the hospital with a hospital band back to court. And she was worried that a bench warrant had been issued in her name, and it had been, because that's what happens when you miss your court date. And the judge, stopped my client's trial, which made him really mad at the time, and, quashed this bench warrant and gave this woman a new date. And that's bad. But the point is that that woman has a failure to appear on her record. And while that is kind of an egregious, but I swear true story, common things happen all the time. Anyone who's ever relied on public transportation in DC to get to work has been late to work, because sometimes public transportation fails you. Sometimes your alarm clock doesn't go off. Sometimes your job says, if you don't show up tomorrow, you're going to be fired, and it doesn't matter that you have court. Sometimes childcare falls through. Sometimes your kid is sick. That there are real life reasons why people practically can't show up to court. And so, having a factor of, did you one time previously, without the opportunity to provide explanation, fail to appear at a court date, and now this risk assessment tool that doesn't allow you to provide extra information is going to say you need to be detained? That's problematic. And it turns out that there aren't any factors that we can think of, that the people who are researching this can think of, that would allow this algorithm to come out with a non-biased answer. And that's because so many aspects of our criminal legal system are biased. So typing in factors that have previously existed in the criminal legal system continues to spit out biased answers. And so that's why there are many different organizations, ACLU, Pretrial Justice Institute, that were previously tentatively all right with risk assessments that have now changed their views. The Bail Project is also, I think, has always been against the use of risk assessments. So that's something that, people wanting reform were really excited about this. But sometimes when you're trying to, change the world for the better, you got to reflect and think, is this actually helping, or is this actually really hurting? And that's where we are right now. And unfortunately, Cleveland does, especially in their municipal courts. So what should reform look like? So going
get to that, I'm so sorry to interrupt you, but there's a point right there. Cleveland Municipal Court, didn't they, and I'm speaking out of mostly ignorance, but didn't Cleveland Municipal Courts in about 2018 put in a model program or a test program on setting bail? And you just mentioned them, and I think that had to do with the risk assessment as well, and the risk assessment was a major part of it, wasn't it? How did that go? Have they come up with data on that?
So data is still ongoing, and I'm going to give, I guess, a preview. We have a fiscal impact analysis report that's going to come out in September that has gone over some of this data. But ultimately, what we're finding, not just in Cleveland, but across the country, is that risk assessment tools seem to be used when they align with whatever the judge was planning to do in the first place. And then they are disregarded when a judge does want to detain this individual. And unfortunately, we are seeing this overwhelmingly on having to do with race, that people of color, especially Black individuals, are more likely to be held pretrial, even if the risk assessment says they're not a risk. Whereas for white individuals, judges seem generally looking at the data as a whole to release people, and it seems like if that's what they were going to be doing in the first place.
Sorry, I interrupted you. Please go ahead. By the way, before you go ahead, Claire Chevrier is the policy counsel for the ACLU, and she is in charge of bail policy for the state, and her belief in what she's doing is obvious by her enthusiasm. So now I'll shut up. I won't say another word, I promise.
Sounds good. And Anthony, did you want to say anything about the risk assessments, or should I move on?
I would agree with you on the risk assessments. I was gonna make a comment on the data that I saw some of the data that was shared from the municipal court, and
Oh,
you know,
please.
they show great numbers. I don't know the exact numbers to be exact, but one of the things that people don't pay attention to is like those numbers can show great and show all the things they wanted to show, but it lacks context and content to go behind it, and it doesn't tell the narrative of how a lot of folks are bound over and things that nature. So it helps that municipal court's numbers. So those numbers tend to lie and show a false narrative and don't tell the whole truth. But that like we're totally against risk assessments because, as you said, it's individual based, and there's no way that artificial intelligence or anyone who has a biased point of view can just make a judgment. And as I said before, each judge has their own bias. One judge hates guns, one judge hates domestic violence. So of course that assessment of that individual who comes before that judge, their bond amount or their detention is 9 times likely higher, and they're going to be held.
Absolutely. So now I'm going to talk about what bail reform can and should include. So right now, which both Anthony and Jonathan kind of set the stage for this, is right now in Ohio, if you're arrested, it's possible based on where you're arrested that you will have the opportunity to post bond without ever even seeing a judge based on a bond schedule. And a bond schedule lists either crime like theft or crime level like first-degree misdemeanor with an associated cost. And some jurisdictions allow for usually a deputized like sheriff officer to make a decision about whether or not it should be changed. But generally, whatever amount is next to whatever crime or crime type of which you've been accused, that's what you have to pay to get free. And so exactly what Jonathan was saying, that cash bail does not promote public safety. It just allows people with resources to buy their freedom, regardless of potentially how dangerous they are. And so that does not promote public safety, and it also does promote wealth-based detention, because a different person with the same amount next to their name charged with the same crime might be detained throughout their pretrial period, or at least detained until they see a judge, even though they were potentially arrested for the same crime. And so what we propose is, instead of using just this monetary amount as the release valve, to create a release valve that applies to everyone. So through a strong presumption of release, the presumption would be that everybody is released unless there is an interim finding that somebody is a risk to a specific individual or is a risk of willful flight, that they're going to get out of here and avoid their next hearings. And so only if those two things exist, then what we argue is that individuals should have a hearing within 48 hours. And that goes to all of the evidence that suggests the enormous hardship that is created when somebody is held in detention, likelihood of losing their job, likelihood of ultimately losing their house, risk of potentially losing custody of their children, that the likelihood of each of those things occurring substantially increases after 3 days. So these hearings should exist within 48 hours. Also, what we need is written findings on the record from judges. As I said before, and as Jonathan discussed, right now it's really easy for a judge to just set a financial condition of release and move on and go to the next person. And unfortunately, often judges aren't required to write down why. So Criminal Rule 46, which was discussed earlier, did include some good language. It included the requirement specifically that all conditions of release have to be the least restrictive necessary, and it specifies that all financial conditions of release have to be the least costly. And we agree with that. That's great. Unfortunately, Criminal Rule 46 stops short of requiring any procedural safeguards that would actually make those things true. So judges do not have to make written findings on the record about what makes it least restrictive and what makes it necessary, or how did I learn that this amount is least costly. And because judges don't have to show their work, they're not. And we see that. I've been tracking since Criminal Rule 46 went into effect in July, that every day in Ohio since, judges have still set financial conditions of release that have led to detention, which is not the minimum, which is not the least restrictive condition necessary to assure public safety. And judges continue to disregard the preventative detention laws and instead just set high conditions of bond in order to detain. So even though Criminal Rule 46 does show that, the Supreme Court and those who worked on the rule do need these changes, it hasn't actually gotten us there. So what we need is this release valve. Instead of using a bond schedule, so money determines whether or not you're free, it should be, is there actually a safety concern? And is there actually a concern you're gonna flee? And if not, you should just be released. There needs to be hearings within 48 hours, and counsel should be provided at those hearings. And there needs to be written findings on the record. So how does that happen? So it could have happened through Criminal Rule 46. Criminal Rule 46 is a rule of practice and procedure that does carry the weight of law, unlike some of the other types of rules that the Supreme Court is able to do. This does. So it could have had a big effect, but unfortunately the language was watered down, as Jonathan discussed, and it's unlikely to. So what we need is legislation, statewide legislation. Or unfortunately, it looks like there's going to be litigation, because there are a number of different jurisdictions across the country that have found that very similar procedures to ours have been found unconstitutional. So it actually makes sense that legislation could provide the details of what needs to change, so that, you know, a court or litigation does not decide it for us. But then there's also a lot of local reforms that can happen. And so, you know, I'm pushing for statewide reform, but there's a lot of things that can happen on the ground. You know, prosecutors, individual prosecutors can choose to ask for OR, or own recognizance bonds. So somebody just signs, like Jay was discussing often happens in federal court. So someone signs instead of having to put up money, which could cause them to be detained. Prosecutors can choose to ask for that more. Judges can create internal reviews. I know that Judge Russo, when he was administrative judge, hired somebody to every day poll who was still in jail based on a bond amount to determine whether or not the judge that's overseeing their case could review to see if they could lower that amount so that they wouldn't be held in jail simply because they could not afford to buy their freedom. Sheriff's offices can also do cite and release. So similar to what happens when you are pulled over for speeding, that you're given a citation and a date on which you can come to court, so that you're foregoing, being detained in the first place. There are a lot of things that can happen locally that could have a huge effect, but ultimately what we need is statewide change, and legislation is the best venue to get us there, because Criminal Rule 46 failed to provide us the teeth necessary to change anything on the ground. And luckily, and I'll take one more minute to say this, that there is huge, widespread support for bail reform. Lots of people are coming at this for very different reasons. I personally am doing this because I want to get people out of cages. And I think that what Brian Stevenson said about how wealth, not culpability, shapes outcomes degrades our criminal legal system, and every lawyer and person should be mad. Some other people are coming at this that this is just doesn't make sense from a taxpayer's perspective, that somebody could be held on a $200 bond for weeks and cost the city $100 a day to be detained. That doesn't make sense. And ultimately, they might lose their job. There could be a depressed workforce as a result. Maybe they're going to have to, apply for benefits that they didn't previously need to rely on. There could be a lot of problems there. Other people are looking at this from the perspective of this is just a government overreach that, violates libertarian norms. So there's a lot of different people. This isn't a Republican or a Democrat issue. This has bipartisan, nonpartisan support, and we all need to work together to make sure that people are not being held in jail simply because they can't buy their freedom.
Just to piggyback off what she said about true reform, we talk about bail reform. A lot of times people fail to include bail reform and police reform as a tandem. A lot of times judges receive police reports and so forth, and the way the police officers write these reports up, a simple jaywalking ticket can turn into a resisting arrest, and that resisting arrest can turn into an assault on the officer. However the officer writes it up. And a lot of times we've seen that some of these officers are lying. We see the corruptness across the country in our police forces. So we need to approach bail reform and police reform at a tandem, because if we don't get true police reform, this is where bail starts. However these officers write these police reports is where they go to these judges, and that's where our bond starts. So we know that African Americans are stopped disproportionately as it relates to our white counterparts, and we see in our criminal justice system that African Americans are detained in jail, higher bonds, and more than likely to plead guilty to crime. So we need to approach both with the same effort and energy.
Yeah, and I'd even add, think about how prosecutors also contribute to this. So the same punch could be charged as simple assault, felonious assault, attempted murder. And so if somebody is charged with attempted murder, the line on that bond schedule is a lot higher, and maybe now they're also, can be considered for preventative detention, when in fact, the stacked charges were just being used as a way to coerce a plea deal. But ultimately, it could affect what bond a judge sets, especially when we're seeing in some of the jurisdictions in Ohio where the initial hearings are 30 seconds by video phone. Maybe the only information that a judge has is the charge, and maybe that charge doesn't really realistically describe what happened or likelihood for successive conviction.
Well, folks, we have now gone from bail reform to police reform to what judges receive, and I cannot hold back, please excuse me. But linked to all of that is indigent defense reform. We are in a position where, and this has been going on for lifetimes, indigent defense, where 80–85% of the people that go through the system are indigent, where with the fees paid to indigent lawyers, while some of them many of them want to do a good job, all of them want to do a good job, some of them want to do a good job, there is not enough money to properly do the cases. We are a system that processes indigents through in the most expedient way possible. And please excuse me for being specific, but you can walk in the courthouse on any given day that's not the pandemic and hear lawyers saying, "Judge, my guy is an asshole, he won't plead." Why is that? Because the judge hires you and the judge pays you if you're a lawyer. So who's the client? So we can go on and talk about all justice reform, and I'd be glad to talk about this forever and ever. And if anybody else has any comments about that or thinks I'm crazy and should have never said it, please tell me. Other than that, Claire, more? Are you set?
So, I want to go back. I want to go back to another issue that you asked earlier, Jay. Like, why are we doing it this way? Why aren't we doing it differently? And one thing I think that's really important to another aspect we haven't really discussed. In defense of judges in Ohio, I think that here in Cuyahoga County, many of them do not have a lot of other options available to them. They don't have a robust pretrial, well-funded pretrial services department where they could say, let's do essentially what Anthony Boddy's organization is doing, which is let's make sure this person's getting their medication, let's make sure their housing situation is stable, let's figure out what their employment situation is, let's supervise them appropriately in a way that's going to allow them to succeed. And one of the recommendations of our bail task force, you recall, Jay, is that we recommended that the county invest money in pretrial services to be able to try to give judges tools other than just set a $10,000 bond on somebody to be able to allow people to succeed in their pretrial release. And so one thing, I guess, that's a question for folks to ask the powers that be whenever you see those people, is that I believe at the beginning of this year, back in the before COVID era, right, in January, February, there was a plan that was pretty well developed in the Cuyahoga County Common Pleas Court to fund, to move some funding into pretrial services, to begin, giving judges a lot of that ability to use other tools other than setting bond. And in the last 5 or 6 months, that plan, I don't know where it sits right now. I think it's sitting on a shelf, but I think it was ready to go. And so I would love to see the county implement that and say, let's move those funds into pretrial services. Let's give judges the opportunity to do other things other than setting high bail amounts. And I think that we could see some of the successes that that the bail project is seeing, and we could do that on a countywide basis.
No, you were absolutely right. I know Judge Russo was sort of was spearheading that idea and leading that. But once things shifted, I'm not saying Brandon Sheed, that's not his goal, but COVID sort of threw a monkey wrench in everything. So hopefully that will be picked up again.
Amen.
And I also want to answer part of one of the questions that was asked in the Q&A feature about what would legislation and would it be expensive? So again, legislation, our goal for what legislation could look like is creating the procedural safeguards necessary so that setting financial conditions of release or cash bail is not the easiest thing. That there should be a strong presumption of release that has to be overcome before a judge sets any serious conditions of release, let alone financial conditions of release, that there should be hearings within 48 hours, that counsel should be provided at these very important hearings that we know often affect the liberty interest. And also, and I don't think I said this before, you know, the Bail Project is all for ending cash bail, period. At the ACLU, you know, we point out that I think it's possible to end wealth-based detention without ending cash bail, as long as there are so many procedural safeguards in place that bail is never used to detain someone simply because they don't have the resources to buy their freedom. And so what that could look like is very strong presumption of release. So most people go home in the first place. Only a small minority get this conditions of release hearing within 48 hours because there's some concern about the safety threat that they pose, or that they will flee. And then if a financial condition of release wants to be set, it should only be because there's a threat of fleeing, not public safety, which Jonathan discussed earlier. And then if it is determined that there is a risk of flight and that the least restrictive condition necessary to deter that flight is a financial condition of release, then there would need to be a robust ability to pay determination to make sure that you are not setting bail in an amount that would cause long-term detention for an individual. So there could be safeguards of what is this individual able to post within 24 hours personally based on income minus expenses. And so the hope would be that it would only be a very small few that would ever get a financial condition of release, and that it would not be allowed to act as a way to detain individuals. And what's interesting is, and we have this report that's going to come out in September that's going to provide all the details about this, this would save a ton of money. Even if robust pretrial services were created for every jurisdiction in Ohio, even if counsel was provided at all of these different hearings, right now, the cash bail system that we have in Ohio is ridiculously expensive because it costs anywhere between $60 and $100 a day to hold somebody in jail in Ohio. So somebody held on a $300 bond spends 3 weeks in Ohio at $100 a day. How much money is that costing compared with around $6 a day to supervise somebody pre-trial, even in a system with really robust pre-trial services? So it just does not make sense from a fiscal perspective. And this kind of legislation would absolutely save money. And we look forward to providing more details about that in September.
We've got a question that's been asked and seconded. It's directed towards Anthony and Jonathan. I just highlighted for you guys. If you could take a look at it, or I'll read it. But while you maybe want to take a look at it, I want to answer one other question about bondsmen in the system. 2 or 3 people asked whether bondsmen play a function by way of monetary of contributions to campaigns. Are they affecting the system by backing judges? And you have the threshold issue of elected judges, that as long as you have elected judges, money will be a factor in the system. Anecdotally, I would argue that that's true, but has there been any data on that actually? I know that we tried to look at that during the bail reform committee, but is there actually any data on that about the amount of money that bondsmen are contributing to the system? Maybe not. Guess not.
The bondsmen were vocal in their opposition to the proposed amendments to Rule 46. Those proposals got a lot of support from across the political spectrum, from the ACLU to the Buckeye Institute in Ohio, but they were opposed by the bail bondsmen.
Follow the money. Sorry, bondsmen may be blameless in this, and I'm just being flip. So here's the question. We heard Mr. Boddy say that defendants' constitutional rights are being violated because the Common Pleas Court has delayed the restart of jury trials to mid-September as a result of the COVID crisis. While jury trials have been on hold, the court has been conducting virtually all other criminal proceedings throughout the pandemic. I'm not sure if that's accurate, by the way, but we'll take it as it is. Does Professor Rich agree with Mr. Boddy's assessment that delaying the restart of jury trials is a violation of all criminal defendants' constitutional rights?
So it's a really serious issue. I mean, you have a right to a speedy and public trial. So, there's an Ohio Speedy Trial Act, which is a statute that gives you certain statutory rights, and you also have a state and federal constitutional right to a speedy trial. You know, I do think that we have to be cognizant of the fact that there's a global pandemic and that is a kind of exceptional circumstance. I do think that one fundamentally important thing that relates to exactly what we're talking about here is it's one thing to delay somebody's jury trial by a month or 2 months. It's another thing to keep them detained pre-trial while they're awaiting that jury trial. So if we release people and say, you know what, we're gonna, due to the extraordinary circumstances, we have to delay your jury trial by a month or two. I'm not aware of, there's not a lot of precedent on, is it permissible, constitutionally permissible to delay jury trials during a global pandemic? But the answer may well be yes. But the question of detaining people for extra time when the detention itself is a high-risk situation with that global pandemic, exactly as as Anthony Boddy talked to us at the beginning, putting people in really serious risk of sickness and death, while also delaying the jury trial. That's to me where it becomes extremely problematic. So I think that the clear first answer to that is, if jury trials need to be delayed, the court must make every effort to release pretrial detainees pending that delay. And the twin detain and delay is extremely problematic.
Anthony?
Quickly answer a question that I'm seeing here about who pays for GPS monitors, because it's particularly interesting in Cleveland. In Cleveland, if you are put on a GPS monitor by the Cleveland Municipal Court, then the defendant does not pay for it. The Oriana House pays for it. It is free to defendants. You have to wear the ankle bracelet, which is very burdensome, but it is free. If your case then gets bound over because it's a felony to the Court of Common Pleas, and you then again get put on a GPS monitor, you have to pay for it. If you're wondering how that makes sense, I'm with you, because I don't think it makes sense. And unfortunately, it's quite expensive. It's around $56 per week. And so if you are out on release for weeks or months on pretrial release, that could become very cost prohibitive. And while the rules specify that if you are indigent, you should not have to pay, that is not what we are seeing on the ground. The individuals are being asked to pay this cost, even if they have public defenders, so there's already been a determination of indigency. And the ACLU of Ohio currently has a campaign, you can go on our website, about asking Administrative Judge Sheehan to change this practice. If we're talking about people being coerced into plea deals, asking somebody to choose between, feeding their children and paying for their own e-carceration is one way that people feel coerced into pleading guilty for something that they have not done. And Cuyahoga should absolutely follow Cleveland and not charge people for their ankle monitors.
One last question, I think, because if we're done at 1, which I believe we are, we have 1 minute. But there is a question about the pretrial services. Is it worth the cost?
That's a great answer, because it piggybacks into what Claire was saying. So the reason why Cleveland doesn't charge for the ankle monitors, that's part of their pretrial services. So as we were saying earlier, with Judge Russo and them spearheading that pretrial services for the county, it hasn't actually been enacted yet. So we're not 100% sure whether or not they were going to pay for the ankle monitors at all. Even though we at the Bell Project still believes that that's still a form of pretrial detention, and it's just basically an adult electronic dog leash or something that keeps a track on individual, and it's not right. But as far as pretrial services, I believe that there should be an investment in a robust pretrial service that would decrease the amount of money that I believe a county or municipality will spend on housing people in jail. So as I said earlier, like with the advocacy work that we provide, if the city of Cleveland and the county does invest in pretrial services, whether it be housing, jobs, rehab, any other sort of services that helps people with basically following Maslow's hierarchy to their most important and better self, that will be a lot less expensive than housing people in jails for months, days, and weeks at a time.
Absolutely. And I want to quickly say, I totally agree with what you're saying, Stephen, in the chat about, what we don't want is no more cash bail, so now everyone gets a GPS monitor. Because most people don't need GPS monitors either. Most people will just come back to court if they're given the date that they're told to come back to court. In fact, some of the best ways to ensure that someone comes back to court is court reminders, just like how all of us end up going to the dentist because we're reminded about it. If we want to make sure people are getting to court, we should be talking about, like, can we pay for their bus passes? Can your court paper serve as a bus pass? That would get people to court. So what we don't want is to have overburdensome conditions of release that actually serve to just push people back into the system. But what we do want for some individuals for whom a judge might have concerns about safety, we don't want the only option to be released into the community with no supervision or jail, because jail is usually overburdensome and not necessary. So if there is some sort of spectrum, but a judge again is required to only set the condition of release that's least restrictive necessary, and they have to put in writing on the record why it's least restrictive and what makes it necessary, then the hope would be that people are not going to be given overburdensome, but that it will actually be individually tailored. So what we do want is for robust pretrial services to be available, but for it to be limited to what's actually necessary, as opposed to right now, the default is detention through bond.
So I think we're set, but please excuse me for one last thing. From what I've taken away from this discussion today and what I've taken away from time is that if you have a modest amount of money, bail will not be an issue in your case, and your case will move along at whatever pace or quality that you would get otherwise. If you do not, it is much more than an inconvenient day or two. It is much more than the pain, the visceral pain of being in jail. Days in jail will change your life. And that seems to be lost at this point. Not here, not among the people here, but as the system takes a look at this and sort of grinds along slowly, it often forgets the people who are involved. Anyway, thank you so much for your time and for listening to us. Domenica, you have stuff to do.
Yeah, I do. Thank you, Jay. Thank you, everyone. Anthony, Claire, Jonathan. It's been a pleasure. I'm sorry we didn't schedule this for longer. The conversation was great. As if you opted for CLE for viewing this program, I will follow up with the survey. Just make sure you fill it out completely. But thank you so much for tuning in. Stay tuned for more real talks. We want to keep the spotlight on these issues. It's so important. So stay tuned. Thank you so much. Have a great week. Bye.
So long, guys. Thank you.